Hello and a warm welcome to World This Week by latestlaws.com. This is a weekly program, so hit the bell icon to get notifications for new videos. My name is Sheetal June, Associate Editor, latestlaws.com, and let's begin with Supreme Court this week. This week, the Supreme Court Constitution Bench continued the historic hearing in the matter of marriage equality for the third week. While making his submission, Solicitor General of India Tushar Mehta informed the court that the centre has agreed to form a committee to address the genuine human concerns of the LGBTQIA+ community. The committee shall be headed by Cabinet Secretary and shall consider and examine the suggestions of the LGBTQIA+ community with respect to the issues faced by them when in cohabital relationships with the persons of the same gender. Attorney General of India Venkata Ramani has also tried to persuade the court to not alter the Special Marriage Act. He said that howsoever enlightened we are on the subject and however neutral we are, if we want practical outcomes, the court should not fundamentally alter this basic text of the statute in the case and see if the solutions can be arrived at. Special Marriage Act is only a law in relation to the institution of marriage and does not create the institution of marriage itself, and thus it is not discriminatory legislation, he submitted. The Supreme Court has held that mere inconsistent averments in the plaint aren't sufficient to conclude that the cause of action wasn't disclosed in the plaint. A division bench of Justice Abhay Oka and Justice Rajesh Bindal observed that while considering the application under Rule 11 of Order 7 of CPC, only the claims made in the plaint and the documents produced along with the plaint are required to be taken into consideration, and therefore when lack of a cause of action is used as a justification for rejection of the plaint, the court must review the plaint to determine whether a cause of action has been disclosed or not, it said. The Supreme Court has held that the precondition of furnishing a bank guarantee for the bail or grant of bail is not sustainable in the eyes of law. While dealing with a criminal appeal wherein the appellant charged for offences punishable under Section 69(132)(1)(a) of the Central Goods and Services Act 2017 made a bail application under Section 437 of CRPC, and the same was granted but subject to submission of bank guarantee of Rs 3 crore, a division bench of Justice Krishna Murari and Justice Ahsanuddin Ahmedullah relied on the judgments in Subhash Chauhan versus Union of India and Anant Bhai Ashok Bhai Shah versus State of Gujarat and others. It was observed that the court in a number of cases considered such a precondition of depositing money or providing a bank guarantee on a number of occasions where the precondition has been deemed unfavorable. Pronouncing a judgment related to the imposition of penalties under Income Tax Act 1961, the Supreme Court has ruled that the penalties cannot be imposed solely based on delayed TDS, tax deductible at source remittances, as there exists difference between failure to pay TDS and a delayed TDS remittance. The division bench of Justice M. R. Shah and Justice C.T. Ravikumar concluded that Section 271(c)(1)(a) of the Income Tax Act is applicable, stipulating that if a person does not deduct tax as required under Chapter 17B, they will face penalties, and the language of this Act specifically mentions failure to deduct tax and not delayed remittances. The court noted that in case of delayed remittances of TDS, Section 201(1)(a) provides for the interest to be paid, and Section 276B of the Act talks about the prosecution for failure to pay TDS after deducting it. It pointed out that Section 271C has been amended to include Section 271C(1)(a) and 271C(1)(b), and failure to pay the whole or any part of the tax would fall under Section 271(b)(1)(b) and not A. In its ruling related to the forfeiture provision of Rule 5 of Rule 9 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act of 2002, SARFAESI Act, the Supreme Court emphasized the crucial role played by the Act in maintaining the liquidity of the finances in the economy. The court also ruled that the power of judicial review would be used solely to safeguard public interest and not to settle private interest or contractual disagreements unless there was clear-cut proof of arbitrariness, mala fide bias or irrationality. The court found that the respondent has not sought an extension for the maximum period of 90 days allowed by Rule 9(4) and has also moved the DRT for an extension, which was not granted. Since no unjust enrichment of the bank occurred due to the forfeiture, the High Court was not justified in exercising writ jurisdiction and directing a refund of 25% of the court ruled. Next we have Delhi High Court. The Delhi High Court has held that under Section 15 of the Hindu Marriage Act 1955, it shall be lawful for either party to the marriage to marry again if no appeal is filed against an ex-parte divorce decree within the period of limitation. A division bench of Justice Sanjeev Sachdeva and Justice Vikas Mahajan observed that an ex-parte divorce decree has the same legal effects as a contested one, and according to the law, and even Section 15 of the Hindu Marriage Act does not differentiate between the two. Therefore, if no appeal was filed within the time limit, either party could legally remarry even if the divorce was granted ex parte. The Delhi High Court has held that victim has an unbridled participatory right in all criminal proceedings in relation to which the person is a victim, but there is no reason to impede a victim as a party to any such proceedings, unless otherwise specifically so provided in the statute. A single judge bench of Justice Anup Jairam Bhambani observed that the law requires victim to be heard in a bail proceeding, but they do not need to be made a party to the petition. The court also suggested that the provision of section 439(1)(a) CRPC should be expanded to include the victim's right to be heard in other petitions related to temporary relief. As per section 439(1)(a) CRPC, the victim has the right to be heard personally or through a representative, and legal aid counsel may be appointed if necessary. The victim should not just be present as a formality but should be able to actively participate in the hearing. The Delhi High Court has opined that the two courts have different levels of authority and jurisdiction, and therefore an order made under one statute doesn't deny a spouse from seeking maintenance under another statute. The division bench of Justice Sanjeev Sachdeva and Justice Vikas Mahajan noted that, however, the amount paid in one case must be considered and adjusted from the amount awarded in another case. If the divorce was finalized and an order was issued under Section 25 of the Hindu Marriage Act, and the family court must separately consider the Section 24 application for the period between the application's filing and the final decision, the court said. The Delhi High Court has held that when exercising contempt jurisdiction, the court must remember that the purpose of the law of contempt is to serve the public interest and enhance trust in judicial system. Relying on Anil Ratan Sarkar's case, a single judge bench of Justice Rekha Palli reiterated that in a case where two interpretations of an order are possible and there is doubt in the matter as regard the willful nature of this conduct, no contempt would lie. Reference was also made to Dinesh Kumar Gupta versus United India Insurance Company Limited, wherein the apex court summarized precondition before a person can be held guilty of having committed civil contempt. First, there must be a judgment or order or decree or direction or writ or other process of a court or an undertaking given to a court. Second, the judgment, etc. must be of the court and undertaking must have been given to a court. Third, there must be disobedience of such judgment, etc. or breach of such undertaking. Fourth, the disobedience or breach, as a case may be, must be willful. Relying on all Bengal Excise Licensee Association case, it observed that the party to the litigation cannot be allowed to take an unfair advantage by committing a breach of an interim order and escape the consequences thereof. The Delhi High Court in a PIL has directed the Municipal Corporation of Delhi to keep conducting frequent raids, seizing illegal substances and taking legal action against people who sell or distribute contaminated water or beverages. The court ordered the MCD that it must continue to make sure that hawkers are not allowed to pass or sell any contaminated drinks such as jaljeera and ruh afza, kanji bottles, colored drinks, soda water, lemon soda, chopped fruits or inflicted water. Now let's have an overview of other high courts. The Orissa High Court, while dismissing the writ petition, reiterated that Section 33C(2) of the Industrial Dispute Act and Labour Court's power under Section 33C(2) is like that of the executing court's power to interrupt the decree for the purpose of its execution. The court referred to the Central Bank of India Limited versus Raja Gopalan, where the Constitution Bench had considered the scope of Section 33C(2) of the ID Act and kinds of claim that fall under the said section were discussed. It was also mentioned that of the claims which would not fall under Section 33C(2), then it was further noted that the Rajagopalan case interpreted that Ganesh Razak case and held that Section 33C(2) of the power can be exercised only when the entitlement has been earlier adjudicated or recognized by the employer and for the purpose of implementation or enforcement of some ambiguity required interpretation. The Labour Court's power under Section 33C(2) is similar to the executing court's power to interrupt the decree for the purpose of its execution. The Gujarat High Court has held that the rights to consume safe and hygienic food is a fundamental aspect of the right to life enshrined in Article 21 of the Constitution. The division bench of Justice N.V. Anjaria and Justice Neeral R. Mehta in this view denied relief to illegal meat shops, emphasized that it is the responsibility of the state authorities to ensure the safety of food, and they fulfill this duty by implementing and enforcing the food safety regulation and other statutory measures. Further, the court observed that the petitioners can not also be permitted to assert unrestricted freedom to do business in meat or to run slaughterhouses on the grounds of religious occasions when they are otherwise non-compliant with the norms and law. The applicants cannot draw from them such unrestricted rights to do business on the canvas. The Bombay High Court has held that under Order 8, Rule 6A of the Civil Procedure Code, the counterclaim cannot exceed the pecuniary limit of jurisdiction of the court. However, there is no bar to the civil judge senior division to entertain the counterclaim which is in the pecuniary jurisdiction. The single judge bench of Justice M.S. Javalkar observed that the counterclaim is a cross suit to enable the court to pronounce final judgment both on the original claim and counterclaim. The Rajasthan High Court has expounded that the SSC or the person who is registered under the GST is entitled to lodge an ITC claim when the department considers the issue of revocation of GST registration cancellation. The court in this view allowed a writ petition and held that the case of the petitioner firm covers the notification dated 31st March 2023 and the petitioner firm can move an application before the competent authority with a prayer for restoration of its GST registration subject to fulfillment of the condition mentioned in the said notification. The Allahabad High Court has held that in order to consider public interest litigation related to corruption by a public servant, the court must first be satisfied with the credibility of the person bringing the plea. A division judge bench consisting of Justice Devendra Kumar Upadhyay and Justice Om Prakash Shukla made the observation while dismissing a PIL filed by a former state government employee who sought action against a current state government employee for alleged corruption, among other things. For seeking protection of Section 11(2) of the Whistleblower Protection Act 2011, one has to first establish his bona fides, the court ruled. Moving on to miscellaneous news. A court in Qatar has adjourned a hearing in the case of 8 former Indian Navy officers jailed on charges that have not been made public after their defense lawyer informed the judge that he was yet to receive all the documents from the prosecution. The first hearing in this trial was held on March 29th, but even as the speculation has swirled about the accusation against the Navy veterans, family sources have said that they has not informed of the formal charges under which the trial is being held either by the Qatari authorities or by the Indian officials who have had consular access with the prisoners. Amid a rise in COVID cases in the country as well as in the capital, Chief Justice of India D.Y. Chandrachud has orally remarked that he has taken administrative action to push for hybrid hearings and has written to the High Courts as well in this regard. The comments came on mentioning made by Advocate Siddharth Gupta concerning hybrid hearings before a 3-judge bench headed by CJI and also comprising of Justice P.S. Narasimha and Justice J.B. Pardiwala. He was flagging the issue of difficulty being faced by advocates in high courts to obtain permission for hybrid hearing even as COVID cases rises. Gupta thus requested for urgent hearing of his plea, seeking the resumption of hybrid hearings in all the high courts. To this, the CJI said that he is seizing off the matter and stressed that he has already taken administrative action in the issue. The Supreme Court has closed proceedings on a petition by women wrestlers alleging WFI Chief Brij Bhushan Sharan Singh over sexual harassment charges. The Supreme Court has asked the wrestlers to approach the High Court or Trial Court for further relief. The top court noted that the purpose of the plea has been served as FIR has been registered and that security has been provided to the wrestlers. The 7 women wrestlers who have leveled allegations of sexual harassment against the Wrestling Federation of India Chief Bhushan had moved the Supreme Court seeking permission to file an affidavit in a sealed cover. The Supreme Court has allowed the National Company Law Tribunal to proceed with its inquiry and any subsequent action against the auditor of ILNFS Financial Services, a unit of infrastructure leasing and financial services that filed for bankruptcy in 2018. The court upheld provisions in Companies Act 2013 that allows for the government to inquire and act against auditors. Dealing with a petition filed by the government against a lower court order in 2020 that said that any action against the auditor is not applicable if they resign. The Supreme Court, however, made it clear that its ruling that it was not making any comments on the merits of the allegation against the auditors. The central government has notified that e-filing of the pleadings in debt recovery appellate tribunals and debt recovery tribunal is mandatory and any form of the filing shall not be taken on record. The Department of Financial Services, Ministry of Finance, via letter dated 3rd May 2023 has further conveyed that all the pleadings and documents should be bookmarked and properly and appropriately indexed. The Delhi High Court has observed that the passport of a minor child can be issued without the biological father's name under varying circumstances and such a relief should depend upon the facts of each case. It was hearing a plea that was moved by a minor child and his mother seeking the deletion of the father's name from the child's passport. It also sought reissuance of a fresh passport. In the end, we have international news. In an antitrust dispute brought by Fortnite creator Epic Games, the US Ninth Circuit Court of Appeals upheld a 2021 decision that might compel Apple to permit developers to give links and buttons for third-party in-app payment choices and avoid paying sales commission to the iPhone manufacturer. The appeals court agreed with the trial court, and Apple's App Store application do not violate antitrust laws and upheld its commission of up to 30% for in-app purchases. A court in Netherlands has banned a man from donating any more of his sperm after he was suspected of fathering more than 550 children. The man, named Jonathan Jacob Meijer, aged 41, could be fined for more than 100,000 euros if he tries to donate again. The shocking case came to the limelight after the foundation and the mother of one of the children filed a lawsuit against him in Hague. The judge has heard the civil case, said the donor misinformed prospective parents about the number of children he has already fathered in the past. The Peshawar High Court of Pakistan has dismissed a petition seeking ownership over legendary actor Raj Kapoor's Haveli in the city. The house was declared a national heritage by the provincial government in 2016. The court dismissed the petition in light of an earlier judgment of the same court pertaining to the acquisition process of legendary actor Dilip Kumar's Haveli in Peshawar, which too had been declared a national heritage. The petitioner told the court that his family had purchased the mansion during an auction in 1969. His counsel claimed that there was no document to prove that the late Raj Kapoor and his family ever lived or owned this property. However, the court said that the matter ought to be taken to the civil court. The mansion is in a depleted condition and its current owners want to demolish it and construct a commercial plaza. However, all such moves have been stopped by the archaeological department, keeping in view its historic importance. Thank you for watching and have a nice day. This is a weekly program, and to get more information, please check the description box, and for weekly updates, like and subscribe to our channel.